Hello, welcome to Legalese. Legalese is a program of legal information presented by the Northern Middlesex Bar Association. My name's Christopher Lilly, I'm your host. Today's topic is premises liability. Premises liability is a topic that we felt would be of interest to the community at this point, in as much as the holidays are upon us. We're all anticipating perhaps inviting people over to our homes, over to our businesses, and there are certain issues of liability that come with that. I'm joined by two guests today. I'm joined to my right, my immediate right, by Roy Pastor. Roy is an attorney who works with me in AIR at the law firm of Lord and Pastor and Lilly. Welcome, Roy.
Hi, Chris.
And I'm also joined by our friend Charlie Nikopoulos. Charlie is president and runs the Nikoupolos Insurance Agency in Harvard. Welcome, Charlie.
Thank you, Chris.
All right, so we decided to focus on premises liability, and I explained the situation of we're all perhaps anticipating having guests over to our homes, guests to our business. To our businesses, and perhaps there are some issues of liability that may arise with that. And I've kind of broken this down into two loose topics, I guess. Injuries that may occur on your premises, and that would be a slip and fall situation, and perhaps injuries that occur not on your premises, but as a result of something that may have happened on your premises. And in this case, we're talking about a social toast liability. Roy, why don't we talk first about slip and falls? I hate the term, but it's a tort that deals with somebody who has injured themselves on property. What is involved with that?
As with any tort claim, any claim of a personal injury, there are four elements that have to be proven by a plaintiff's attorney. Firstly, you would have to owe a duty of care to the person injured. A duty of care is some responsibility, some legal responsibility towards that person. Second, you would have to breach that duty. You'd have to somehow fall short of that responsibility.
Fail to live up to the duty.
Absolutely, and the third person would have to be damaged, have some sort of damages, whether personal injury damages, monetary damages, somehow be damaged. And fourth, there has to be the breach, your failure to act or act in an unreasonable way would have had to be the cause of those damages. There is a fifth element there's a fifth consideration that's not part of the legal elements, but it certainly drives litigation, and that is that's insurance coverage. Even if all of those four elements are met, a plaintiff's attorney will look to see where the insurance coverage is to try to identify any potential defendants. I assume that's why Charlie's here today.
Well, Charlie's always welcome to attend. Charlie, the insurance and how that comes to play on let's say a slip and fall that occurs at somebody's home. What sorts of insurance might be available to the homeowner, the prospective defendant, that would perhaps step in and provide them with some degree of protection, and what sorts of protections?
On the homeowner's policy, liability is part of the policy. Not only covers your property, but it covers you for slips and falls, slander. So if someone were to slip and fall on the premises and the rake was in the way or the hose, obviously they would have to prove negligence, but the insurance policy would respond to that type of claim. You could have $1 million limit of liability, and I recommend that you have an umbrella that sits over and above that to give you that added protection, just in case it's a significant size claim.
Okay. What is an umbrella policy?
An umbrella policy is excess policy, excess limits that go over and above your homeowner's policy as well as your auto liability policy. It's added protection. Usually people that have assets. It they have a nice nest egg. They want to protect. They're the typical type of client that would purchase that type of policy.
Okay. The homeowner's policy, can you spell out what's involved with that?
The homeowner's policy, from a property and liability perspective, covers your contents inside, covers your home itself, fire, theft, vandalism to it. In the liability section of that policy, will give you that protection for any type of liability that someone deems that you were negligent for. So basically, if you had a party at the house during the Christmas time or Thanksgiving, you had people over and someone were to get hurt on your premises, they slipped and fell inside or outside, it will provide that type of protection for you.
Now, I began the show talking about homes, but also about businesses.
Sure.
So you have slips and falls that can happen at a person's home,
Mm-hmm.
but that can also happen at a business.
That is correct.
Two different types of policies come into play in those scenarios, correct?
Sure.
What comes into play?
On the business end, whether someone's on your premises or you're on their premises and it's part of your occupation, your liability would respond if you cause bodily injury or property damage to someone else, if you slandered someone, harassed someone in that respect. The business owner's policy also covers the business owners not only for liability but for their personal belongings, their building, if they own the building, as well as their personal property that's in there for business use.
Now, that distinction between personal and business is actually an important one in as much as somebody may be looking to go under their homeowner's policy for certain protection and may find out that their protection is not there, correct?
That is correct. The way I like to look at it is, and we tell our clients, is anything business related pertains to your business insurance policy. Anything personal, non-business, pertains to your homeowner's insurance policy.
So sometimes if a claim is made, you may have an insurance adjuster suggesting, well, we don't believe that this is in fact related to your personal, to something personal to you, but really was related to business.
That is correct.
So let's say, and I think you and I were talking earlier about a scenario where you have a business party at your home.
Sure.
And in that situation, you may have your homeowner's policy insurer saying, no, that's covered by our business exclusion, and therefore cannot be part of that.
That is correct.
And perhaps you may have a business policy adjuster saying just the opposite.
That's correct.
Okay.
And after they investigate the claim, they end up hashing it out, determine exactly where the exposure came from.
Sometimes it makes sense to have both policies with the same company so that you don't have the same company suggesting two competing reasons why they can't pay.
Exactly. They're not pointing at each other saying really who's at fault. Yeah,
Sure.
that makes sense.
And one other thing, there are many exclusions on most policies, whether it's business or home, and you really have to be a good consumer to speak with your agent. An agent in Massachusetts is not obligated to tell, not legally obligated to tell the consumer what policies are available for them. You have to ask the right questions. You have to explain to your insurance agent what risks you could potentially have, both in your home and in your business. But if your agent just forgets to tell you, it's not. You have to be your own advocate, in this situation.
So let's get back, Roy, to the situation involving a slip and fall at somebody's home from the point of view of a plaintiff's attorney. Mm-hmm. What are some of the duties that you might be exploring as a plaintiff's attorney?
Well, basically, the obligation, the duty towards another person depends primarily on the relationship between those people. You can have firstly, there's a distinction between people on your property legally and trespassers. You owe a different duty of care. You have a duty of care to everyone on your property legally, whether you've invited them, they're business invitees, whether they're social guests, whether they're just people that, door-to-door salesmen that you can anticipate are going to be knocking on your door as you have a reasonable duty of care to keep the property reasonably safe. For trespassers, and that again that will vary depending on the certain conditions and the circumstances, particular circumstances of the property. For trespassers, you have a duty not to be reckless, you can't put out traps for trespassers. You can't have anything that's clearly dangerous without putting at least signs up or warnings. While the duty towards a trespasser is less, it doesn't mean that you can go out and create a hazard for trespassers. So the duty will just depend. And we also have in Massachusetts, Massachusetts is a comparative negligence state.
What does that mean?
So that means, and it's different from other states that are pure comparative negligence. We do not have a pure comparative negligence. What it means is that you have to be at least 51% liable to be held responsible. If someone is injured on your property, and you go to trial, say they claim that your walkway, stones were loose in your walkway and it created a hazard, and they tripped, and you go to trial. The judge will read, there will be jury instructions read to the jury. It'll say, because perhaps it was the injured person who damaged the walkway on the previous visit, who knows? But the judge will read the instructions, and the jury will be asked, was the plaintiff negligent? And the jury will be asked to say yes or no. If the plaintiff was negligent, what percentage of negligence out of 100% was the plaintiff negligent? They'll ask the same thing from the defendant. Was the defendant negligent? Okay? And if so, what's the percentage? So if the defendant is less than 51% liable, so the person being sued is less than 51% liable, then he gets nothing. If, for instance, the jury says, okay, the person being sued, the homeowner or the premise owner, is 80% at fault, and the person suing was 20% at fault, the jury will come out with a number for damages, whether it's a personal injury, lost wages, whatever the damages are. Then the court would, if it was 80% and the person suing was 20% liable, the court would decrease the amount of judgment award by 20%, the amount of percentage that the plaintiff was liable.
Okay.
So in other states, it's pure comparative negligence. Florida and some other states have been traditionally pure comparative negligence, where the person suing could be 90% at fault. And while the judgment would get reduced, they would still get 10% of it. In this state, you have to be more at fault than the other person.
Let's break down the policy a little bit here. Not only is there something called coverage under the policy, where they may pay for what a judgment might be up to a certain point, there's also a duty to defend for the insurance company. Charlie, that duty to defend is to provide an attorney to represent the insured, correct?
That is correct.
And what are some of the other benefits that one finds in a policy?
Well, they have an attorney that's going to work on their behalf that also represents the insurance company, so there is consistency there. There's also, within the policy, various limits, sub-limits. You have medical expenses, a goodwill type of coverage where you slip and fall. You say, listen, go get it taken care of. Send me the bill, I'll take care of it, to prevent a legal lawsuit. It's like goodwill type of insurance.
Now that's referred to as med pay, correct?
Medical payments, yes.
And that med pay doesn't require a showing of negligence, correct?
That is correct. It's a no-fault type of coverage on the policy. But if someone were to sue and say, no, you were negligent, then the larger limit of, let's say, $1 million, if you had that coverage, would kick in and provide coverage along with the legal defense. And it's a beautiful thing because you have a team working on your behalf. and you don't have to worry about if you don't have an attorney as a friend, or you don't have a home or personal attorney, you have someone there that's going to really do a good job for you.
Now, theoretically, that attorney is representing you, the defendant, the homeowner, up to the amount of the policy.
That is correct. That is correct.
So the policy has a certain range to it, correct? How does that work?
Well, basically, for bodily injury or property damage to someone else, you have, again, if you choose a $1 million limit, for example,
Okay.
once those limits are exhausted, then you're on your own. And
Right.
so that's important, and it depends on how the severity of the claim itself.
So that's an important consideration when somebody's coming to you looking to purchase insurance, is the extent of protection that they may in fact need, correct?
That is correct.
Okay.
We talked about duty before. Because you as the insured have a contract with the insurance company, it's your insurance policy, they have a duty to act reasonably on your behalf. So they have a duty to reasonably investigate the claim. They have a duty to settle it within a reasonable time frame and an amount, so as not to expose you to personal liability. That's a whole separate relationship.
That's right.
But that contract also creates a duty towards the consumer.
That's right. Yep.
Now, as an attorney for perhaps a defendant, you might find yourself actually battling with the insurance company as to what sorts of coverage might be available, correct?
That is correct, and it's not uncommon. Normally, when we're dealing with, well, actually, if you're dealing with a lawsuit, you're going to deal with two people. You're going to deal with the attorney for the insurance company and the defendant, and you're going to deal with the adjuster from the insurance company. So most of the time, the negotiations is not even with the attorney, it is with the adjuster for the insurance company. You'll also be arguing coverage issues. So depending on the kind of a claim, what type of claim, the insurance company may be saying, we're not going to cover you. We have no coverage for that. Our insureds, doesn't have insurance for that particular cause of action. So you're dealing with, and again, when I first started, we talked about that fifth consideration, which is insurance coverage. One of the things if a person is sued, they have the right to file bankruptcy under the federal bankruptcy laws. So if I have a client that has an egregious amount of injuries, but there's a $20,000, say, motor vehicle policy, it is a very difficult situation because the other person who has a $20,000 minimal policy may not have anything else. Even if you were to get a judgment against them, they're going to wipe it out in bankruptcy. And it could cost, $5,000, $10,000, $15,000 in litigation costs to get to that judgment anyway. So it becomes some very difficult choices would have to be made. Some people are not sued simply because they don't have insurance.
They're called judgment proof, I guess.
They're judgment proof, and then it becomes which is not the best way to go through life, but
Sure.
It is a consideration if you're going to bring a lawsuit against someone who committed a tort, a negligent action that injured your client. You have to advise the client whether or not you think you'd ever be able to collect on a judgment, and sometimes the answer is no.
And that's where rules of bankruptcy come into play.
That's right.
All right, let's switch gears here a little bit. We were talking a little bit about slips and falls. I know, Charlie, you brought up an issue of a possible issue of slander as another, and there's imagination can run wild as far as the possible types of torts. But I think we're focusing on slips and falls, but also social host liability. And Charlie, you've seen. I imagine social host liability or liability dealing with bars and serving people.
Sure.
And business owners' policy would cover that sorts of thing, where somebody has been served, that person then goes out and then gets into a car accident, and a third party is injured.
That is correct. The liability policy is the liquor liability portion of their business owner's policy. Sometimes it's part of it, sometimes it's a separate individual policy. So if they served you one drink, it doesn't matter, multiple drinks, just one drink, if that individual left the premise, or when they leave the premises, got in an accident, and that person would obviously get sued, and they would track down where he stopped for any type of alcoholic beverages, and they would bring in that entity.
So if
for the
that
loss,
person
yeah.
who goes out and gets into a car accident has minimal insurance that's not going to cover it,
Exactly.
that's the situation that Roy has touched on, then there's the ability perhaps for that person to look to the premise where that was in fact, where the drink was in fact
That
served.
is correct.
Roy, can you explain some aspects of social host liability and what's involved there?
There's been generally an obligation placed on the host not to serve alcohol to intoxicated persons. That's a duty to those people, the people they may injure. It's not considered reasonable to do that. And again, if I were, as you stated, if I were a plaintiff's attorney, if somebody came to me and they were injured and they had $100,000 worth of injuries, lost wages or $200,000, and there was they were hit by a person that was under the influence or intoxicated, they only have a $20,000 policy. I have to look elsewhere on behalf of my client to see where else I could collect. And since the law does impose liability on people serving the beverages, then that's where I would look as well. The dram shop, it was at one point very little, was not, at one point there was not, there was little liability to someone in a private home as a host. They dealt with the Dram Shop Act, which had to do with restaurants, bars, public locations that were serving alcohol, and they were considered to have a high level of responsibility. But in the last 20, 25 years, we've seen a shift in the law, and now those kinds of responsibilities have been placed on the private homeowner. So if you're serving someone who's intoxicated, somebody's under the influence of your home, and they go out and injure a third party, you may have liability for which you may or may not be covered by your homeowner's policy. The law also makes a distinction between on the age group. It is unlawful, it could be a criminal violation if you allow individuals below the age of 21 to drink in your home. We're coming up with holidays and graduation parties. You're not allowed to permit underage drinking in the home. And if someone goes out and injures a third party, you may have both criminal and civil implications.
Now, the criminal implications are by statute,
Yes.
correct? And how does that work?
The criminal
Yeah.
part of it. If you are a homeowner and you've hosted even if there's no accident, there's no tort. It's independent of each other. So if the police raid your neighbor calls and complains, and the police come in and find underage drinking in the home, you can be charged with a crime for allowing that to occur.
And we're talking about a situation that involves an individual who has been drinking. First we were talking about the bar, but now we're moving into the home situation where that person might have been drinking and gets into an accident with a third party, that third party then coming after
Yep.
that person who was not the person who was drinking, but the person who was serving the drink. So the issue of service of minors, but also the issue of service to an intoxicated person. How does that work?
Well, it is foreseeable. If you are serving alcohol to someone who is, to a reasonable person would appear to be under the influence or intoxicated, it is foreseeable that person could go out and hurt someone. So the law places a duty upon you not to serve those people any more alcohol. And if they go out and they hurt someone, then you've breached that duty, and that duty extends it's foreseeable that there's a third party involved. That duty extends to those people, and if there are damages, you could be held liable. You've broken that duty.
What about that person that goes out and drinks, that goes to a home and drinks, and then goes out and they injure themselves in an accident? Does that duty extend to that person? Does that person have the same rights as a third party who got injured by the drunk person?
Generally, as a general rule, the law does not impose liability on a host for injury sustained by that person. So if you go out, you've served somebody alcohol, and they get into a one-car accident, hurt only themselves, the law assumes that those people are in the best position to take care of themselves. It is really the third party, the innocent person, that has the claim.
And Charlie, the extent to which there might be insurance available to the home, we talked about insurance to the business, but insurance to the homeowner that might protect against social host.
Yes, it's like host liquor liability for a homeowner. Plays similar role as the commercial, but it's friends coming over, having a Christmas cheer, and basically if they serve 1, 2, or 3 drinks, it doesn't really matter. If they go somewhere else and they're driving and they injure someone, the policy will respond to that. They'll have to obviously prove negligence, but it would respond and they would have legal defense.
So I'd say it's certainly important for people to look at their homeowner's policy, look at their business owner's policy to the extent that that's appropriate, and to determine, make sure that they're covered for these types of scenarios. I want to thank my 2 guests for joining us here today. I think this has been a good topic, a topic of warning, but also a topic of education that I hope has been instructive. Roy, thank you. Charlie, thank you. And I want to thank you folks in the audience for attending to our program, and I hope it's been helpful. I hope it's been educational. I will caution you that this is a program of legal information, of general information, and that nothing said here should actually be relied upon in your critical decision-making processes. That you should, in fact, if you do have a question, you do have a situation, talk to local counsel. That's what they're there for. Again, I thank you, and I wish everyone happy holidays.
Thank you. We're coming to your house for holidays.